Week 11, Video 10. Namaskar. Ethical challenges under courtroom constraints. Presenting linguistic evidence within legal boundaries. The courtroom has its own language and its own limits. Welcome back. Today we explore how courtroom structures and legal constraints shape our ethical responsibility as forensic linguists. Inside the courtroom, you're not working in a laboratory. You're not writing a report in quiet isolation. You're responding to questions in a space governed by procedure, law, and hierarchy. Ethical clarity becomes essential because courtroom constraints can influence how evidence is interpreted. Understanding courtroom boundaries. Law shapes language. Courtrooms restrict what experts can say and how they can say it. The expert must answer only the question asked, must avoid volunteering extra information, must not provide opinions outside their scope, must follow judicial instructions, and must fit explanations into legal formats. These boundaries protect fairness, but they also challenge experts who are used to academic freedom. Ethical linguists adapt to these constraints without compromising scientific integrity. When the court seeks certainty in a discipline built on probability, judges often ask for definitive answers, but linguistic evidence rarely provides absolutes. The ethical dilemma arises when the court wants a conclusion which is a yes or no, but your method supports only probability. A responsible linguist says, this analysis suggests, or this evidence is consistent with, rather than saying, this proves. Neutrality requires resisting pressure to provide more certainty than the science actually allows. Handling leading questions, staying ethical under legal tension. Lawyers may phrase questions in ways that subtly push you towards a particular answer. For example, based on your expertise, this is clearly a threat, isn't it? They may be asked. A neutral expert clarifies the text contains linguistic elements associated with threats, but interpretation requires contextual consideration. You do not fight the lawyer, you reposition the answer within scientific boundaries. This protects objectivity and maintains dignity in testimony. Cross-examination pressure when ethics and advocacy collide. Cross-examination may involve attempts to discredit your method, to twist your statements, to push you to contradict yourself, or interpret your findings beyond your intention. Ethical linguists do not become defensive. They remain calm, restate the method, and bring the conversation back to evidence. The strength of testimony comes from consistency, not from confrontation. Case reflection. The ethical danger of over-elaboration. In a landmark case involving authorship analysis, an expert overstated the reliability of a short text sample. They meant to help the court understand, but the explanation drifted into speculation. The judge questioned the scientific basis of the testimony, weakening the impact of the analysis. Ethical restraint means providing the amount of information requested, not more, not less. When the courtroom format distorts linguistic nuance. Court systems often compress complex linguistic phenomena into rigid legal categories: truth or falsehood, literal or figurative, threat or non-threat. But language is fluid. Meaning emerges through nuance. The ethical challenge is balancing linguistic truth with legal necessity. Experts must simplify without distorting. Oversimplification can mislead. Over-technicality can confuse. Ethical clarity lies between these two extremes. Dealing with judicial misunderstanding, correcting with respect. Judges are generalists. They may misunderstand linguistic terminology. If a judge misinterprets your report, your responsibility is to clarify respectfully. Your Honor, to avoid misunderstanding, may I explain this differently? Respect is non-negotiable. Correction must never sound confrontational. Ethical expertise is grounded in humility and clarity. When lawyers misuse your foundings, setting boundaries. Sometimes lawyers selectively quote reports to strengthen their argument. Ethical testimony requires presenting the accurate context. For example, my conclusion was conditional on sample size, which remains limited. This neutral correction ensures that the court receives the full picture. Experts must guard their work from misuse without appearing adversarial. Avoiding performative expertise. The courtroom is not a stage. Experts sometimes feel the urge to impress using complex terminology, dramatic phrasing, or confident tones. But performative behavior harms your credibility. The courtroom respects experts who speak plainly, calmly, and sincerely. The goal is not admiration. Let your analysis be spoken. It is clarity. Ethical testimony avoids theatrics. Let the data speak. Let the analysis speak. Balancing scientific rigor with time constraints. Court schedules can be tight. Judges may ask for brief answers even when issues are complex. Ethical linguists adapt by structuring explanations concisely. Method, observation, interpretation, limitation. This structure preserves scientific rigor while respecting courtroom time. Responsibility includes adapting without compromising truth. Recognizing when not to answer. Ethical silence. When a question falls outside your expertise, you must decline. Ethical silence protects justice. Saying, I cannot answer that question because it lies outside linguistic analysis demonstrates maturity, not inadequacy. Courts appreciate honesty. Inside the courtroom, ethics speaks through you. Thank you for being part of this session. The courtroom challenges experts to balance clarity, precision, humility, and courage. Ethical integrity becomes visible in every answer you give. In the next video, we look at the institutional pressures and how to maintain ethical independence while working with investigative agencies, law firms, or media stakeholders. Thank you.